Hello to everyone. It's a pleasure for me on behalf of the International Association of Youth and Family Judges and Magistrates to welcome you to our second webinar on COVID-19 and its impact on justice and children's rights. My name is Eduardo Melo. I'm judge in Brazil and also the editor-in-chief of the Chronicle, AIMJF's journal, and I'm coordinating this webinar's program. Since AIMJF's foundation in 1928, this association took part in many of the most important moments of children's rights history at the international level. Today, with members in more than 60 countries, organizing world congresses every 4 years, the last one in Paris at the UNESCO House in 2018, we are proud to offer to our members and to a larger community in the world a variety of initiatives aiming to improve the justice system and children's rights. These activities, focusing always in comparative approaches, range from study tours every semester in one country to researches, both on jurisprudence and on the organization of the justice system, the elaboration of guidelines, a bi-monthly newsletter, and our journal, the Chronicle, with theoretical and practical analysis of the most important subjects that judges, magistrates, and legal professionals have to deal with when working with children's rights. We believe that the international dialogue has always played a major role in the improvement of legal systems regarding children's rights. We're very pleased to have you as our audience and also as our member, inviting you to join our association. Please visit our websites for further information. Now, with this monthly webinar program, we'll have one more opportunity to be close to you, inviting prominent members, academicians, and legal professionals from different countries and legal systems to discuss with you contemporary issues on justice and children's rights. The importance of the subject of this webinar, balancing the right to health and the right to family life, is self-evident. The whole world is under the pressure of COVID-19 in different stages of risk contamination by this threatening virus, with a wide range of restrictions that are affecting children's rights in particular and the justice system as well. The variety of situations in which the balancing of those rights could take place reinforce its importance and the reason for why we have chosen it for one of our webinars. Divorce and visitation, children in alternative care and the contact with their parents, parents deprived of liberty, youth offenders deprived of liberty and their need to have contact with their families or their children, children in need of medical assistance and the right to have their parents with them in hospitals, and so many others. We won't be able, of course, to cover all the situations, but we are aiming with this webinar, on one hand, to highlight the reasoning that is prevailing in different parts of the world and to offer an opportunity to understand the criteria and the circumstances taken into consideration when these situations are brought to the justice system. And on the other hand, to understand how the justice system has organized itself to face such challenges. Therefore, I'm very pleased and very glad to have with us and to introduce to you the speakers of this webinar. We have 4 speakers: Judge Joseph Moyersoen, Honorary Judge in Genova in Italy, Professor Magdalena Arczewska from the University of Warsaw in Poland, Judge Jean-François Noël, who is a judge in Quebec in Canada, and Judge Connie Mocumie, who is a judge in South Africa. We'll have their presentation, 15 minutes for each of them, and then we'll have the opportunity for a dialogue and to answer questions raised by you. Please write your questions on the chat. We'll begin with Joseph Moyersoen, who is graduated in law at the State University of Milan in Italy. He has specialized in children's rights. He served as honorary judge at the Juvenile Court of Milan for 15 years and has been president of the International Association and also afterwards the International Association European section. Actually, he's honorary judge at the Juvenile Court of Genova in Italy, and also focal point for external relations and international cooperation of the Italian Central Authority on Inter-Country Adoption, and teaches in several masters level 1 and 2 and specialization courses on children's rights. I have had also the pleasure to work with him as Secretary General in his mandate, and it's a great joy for us as association and for me personally to have you with us. You have the floor, Joseph.
Thank you, Eduardo. Hello, good morning, good afternoon to everybody. Bonjour, bon après-midi à tout le monde. Buenos días y buenas tardes a todos. Thank you for the invitation. I go directly on the presentation. I hope to find it. Okay. You can see it? Yes? Okay. I just click here. Perfect. Well, I think it's very interesting that the topic that you choose, balancing the rights to health and the rights to family life in different contexts. And I would like to talk about the Italian experience. Okay. First of all, I think it's important to give some basic legal framework in Italy, because both are constitutionally guaranteed. The right to the family life and also the right to health, if you see the article that I wrote in the presentation. And of course, Italy is a member of international organization as European Union, that I will not talk about it, but also have competence on these specific issues. But I would like to underline the importance that had the European Convention on Human Rights, in particular the Article 8, concerning the right to respect for private and family life, because in the second paragraph, he say explicitly, there shall be no interference for any public authority with the exercise of the right, except such as is in accordance with the law and is necessary in a democratic society for the protection of health. The Article 8, for the Article 8, Italy and also other members of the Council of Europe have been sentenced for having implemented correctly the Article 8. And for this reason, I would like to mention it. Concerning the COVID-19 in Italy, first of all, I have to say that at the beginning of the pandemic, Italy was the first European Union country strongly affected by SARS-CoV-2, but also still one of the most strongly affected with Spain, UK, and others. If we see the data updated yesterday, 24th of June, 2020, in Italy, more than 230,000 people were infected, and more than 34,000 people deceased. And test was made on more than 5 million people in Italy. Of course, it's not a higher number of tests made, because in Italy we have more than 60 million people. Concerning the civil justice system in general, I have to say that the Italian constitution doesn't foresee a state of emergency. The Article 78 only regulates the state of war declared by both chambers of Parliament, Italian Parliament, according to which Italian government is given the necessary powers. Two steps were made in Italy. The Italian government, the first step, declared a statutory state of emergency according to Article 24 of the Civil Protection Code. According to this law, civil protection orders can be adopted in derogation to any current provision with the limits and with the methods indicated in the resolution on the state of emergency and in compliance with the general principle of the Italian legal system and also the European Union rules. The second step, Italian government issued several decree laws. In example, government acts with the force of law that according to the constitution can be promulgated in case of necessity and urgency and must be validated by the Italian parliament within 60 days. Of course, some sections of these decree laws adopted by the Italian government contain immediately applicable provisions, while others gave to the Italian government the power to issue secondary legislation. For example, decree of the presidency of the Council of Ministers. Of course, it's a complex situation in Italy for the very high number and the diversified legal structure of the provisions introduced to deal with the emergency situation. The key parts of the justice system were contained in 4 decree laws, number 11, 18, 33, and 23 and 28, sorry, containing specific provisions on civil and criminal justice. The emergency provisions established in 2 different phases. Phase 1, from the 9 March to 11 May 2020, with the automatic rescheduling of all civil and criminal hearings, except, of course, for urgent matters, such as in the civil sector, all proceedings connected to the protection of fundamental rights. We will see later for the juvenile justice system what's happened. From 11 May to 31st July 2020, the court presidents, after consulting the health authorities and the representative of legal professions, could adopt measures and guidelines with regard to the scheduling and the carrying out of the proceedings. I mentioned an example protocol also made for the most number of the juvenile court. But coming to the juvenile justice system, I have to say something about the system in general in Italy, because we have a population with, as I said already, more than 60 million people, and quite 10 million are children, the 60% of the population. If we can count, because in Italy we have 29 juvenile courts, and the competence of the juvenile court, the territorial jurisdiction, is at the district of the Court of Appeals. If we can count more or less, we have 350,000 children for each juvenile court under the control of each juvenile court. The competence both is civil and criminal proceedings. In Italy, we have the 2 competences of the juvenile court. For criminal proceeding is more easy because it's a children that committed a crime in the age of the criminal responsibility from 14 until 18 years of age. In civil is more open sector with a lot of specific issues. For example, domestic and inter-country adoption, because in Italy is a judicial procedure. Administrative measures, for example, taken for children who committed crime under the age of 14, and child protection measures, alternative cares, and so on. Decisions in Italy are made by a bench every time. The bench is composed by 4 judges, 2 professional judges and 2 honorary judges. The last specialized in human science. This for having a holistic approach in each case. 1 man and 1 woman to respect also the gender approach, except for the preliminary investigations and for the preliminary hearing of the criminal proceedings. I mentioned also the training because in Italy, during the pandemic, at central local level, the Superior School of Magistrates have done training on the COVID-19 and the provisions implemented to be implemented. Now also by video conference, during also not only during the lockdown period, but also after. Concerning the appearance to the juvenile court proceedings during the lockdown, all the ordinary civil and criminal proceedings hearings have been postponed. Ordinary, because for the civil and criminal proceeding hearings that have been maintained in the juvenile court, special measures of protection have been implemented. Then that wasn't postponed. We had to implement this kind of health measures. For example, I just mentioned some of them: temperature control at the entrance of the juvenile court, mandatory mask wearing requirements for everyone, not only judges, prosecutors, and the administrative staff. In this case, all devices and equipment have been furnished by the Minister of Justice, but also lawyers, social services staff, residential institution staff, children and parents, and so on. In respect of social distancing, even in the juvenile court rooms, 1 meter each. And of course, is a problem that we confronted also the other countries. In the small juvenile court rooms, the identification of the maximum number of people who can stay in each hearing, and also installation of plexiglass screen. Concerning the video conference hearing, for health reasons, the Article 83 of the first decree law that I mentioned provided, the second one, provided the possibility of carrying out civil and criminal proceedings hearings by video conference. In Italy, we adopt the Microsoft Teams platform, virtual room, adopted by the Italian Minister of Justice and implemented in each court, even in each juvenile court. Of course, in this case, concerning the contact of children with their family, this is a specific issue that Eduardo mentioned at the beginning of the conference, of the webinar. This was maintained where possible, but during the lockdown were not possible. I can make an example: a child living with their parents or in alternative care, and the other parents or both parents living in another region. For the lockdown, we, with the support of the social services, activate other forms like a video call to maintain the contact as possible. And also, concerning the video conference hearing, there is a very specific indication. For example, in the minutes of the hearing, we have to write how, which modalities were taken for the hearing, for example, by video conference or vis-à-vis the visu. I would like to mention also some good practices, because during this period of the pandemic, we learned really a lot. And I think we can make treasure of what we learn for the future. For example, we adopt, as I said at the beginning, protocols and agreements at local level by quite each juvenile court with a representative of lawyers, in particular with lawyers associations specialized in family and children rights. These protocols were very detailed, both in criminal and civil proceedings, what we have to do before the hearings, what we have to do during the hearings, and after. This is very important. I can mention the one that I know from the Juvenile Court of Genova, but also from Milano and other towns, are very well made, discussed with the representative of lawyers, of course. And concerning the video conference, I think we can maintain for some proceeding hearings in civil matters. For example, unaccompanied foreign children living in residential institution that are not very near the juvenile court. I would like to remind you that the juvenile judge in Italy is not a judge of proximity, because we have 29 juvenile courts. It's not a lot with 60 million people. Concerning the digitalization also, I think we can learn also for the civil proceedings files, we need to implement it, as is already done in the high number of ordinary civil courts. I didn't mention you, but the ordinary civil court is competent for separation, divorce, and also the right to visit between the parents and the child, and also for the tutelary judge. And finally, the strengthening of networking among all those involved in the juvenile justice system. I have just 1 minute, and I would like to say something about inter-country adoption proceedings, because I work a lot on it. I think I have to mention the great and amazing cooperation that the Italian Central Authority on Inter-Country Adoption, CAI, found during the pandemic lockdown from the other central authorities, both from receiving and origin countries. In particular, I have to mention from South American countries. Also, Italian embassies and consulates, accredited bodies, juvenile courts and social services, in the best interest of the child to conclude the ongoing inter-country adoption procedure. I just make 2 examples. All the Italian adoptive parents, 47, that were blocked in the country of origin could come back. The implementation of video conference also in this kind of procedure for the different steps, in particular also for matching in some countries. A special flying travel was organized for children adopted from Haiti, because the Italian adoptive parents couldn't reach in Haiti the children, even if their adoption procedure was already concluded. All this shows that when everyone works together for the same goal, the best interest of the child, the results are there. Thank you.
Thank you very much, Joseph. It was very interesting to understand how you have structured the justice system in Italy and the particular aspect of inter-country adoption in this difficult moment. So thank you for your presentation. Now I'll introduce you to Professor Magdalena Arczewska, who, as I said, is a professor at the University of Warsaw. She's both a sociologist and a lawyer. She's graduated in the Institute of Applied Social Sciences of the University of Warsaw and in the Faculty of Law and Administration of the same university. Nowadays, she works at the Institute of Applied Social Sciences of the University of Warsaw. She's a member of the board of the Association of Family Judges in Poland and also editor-in-chief of 2 journals, the Third Sector Quarterly and Abused Child Theory, Research and Practice. She's also a member of the Chronicle's editorial boards, with whom I have the opportunity and the privilege to exchange ideas to provide you a good journal in our association. And it's a pleasure to have you with us, Magda. You have the floor.
Thank you very much, Eduardo, to introduce me. Hello, everybody. I would like to share with you about my findings, because before our seminar, I asked my friends from the board of the Polish Association, how does it works in practice, all these rules of law changing now? How do they work? Or what do they think about the changes, about the circumstances we have now in courts? And I would like to share you with my presentation. On the first part, I would like to show you what kind of cases are run now in Polish courts and how does it look in practice. Actually, I also now finished big research. I make interviews with foster families in Poland. I made about 45 interviews, And I also talk about the contact nowadays with the children with the biological parents. How does it work? And I would like to also share my findings about it. Now I will share my screen. Does it work? Perfect. Okay, so that's an example. That's the list of cases examined by the regional court in Warsaw during the epidemic. Of course, I checked also in the other regional courts in Poland, so it looks the same. That's why I choose the Warsaw court as an example. And the period of time we are talking about, these are 2 months, because the lockdown in Poland started in the middle of the March, and it finished, we can say it finished on the end of May. Now the courts are trying to work as before the pandemic, and it's important to say that now we have about 34,000 people with the infection. Of course, that these are people who were diagnosed. Not everybody were diagnosed, that's for sure. So, so all the procedural and judicial time limits in these cases shall run as planned. And during the state of the epidemic or the epidemiological threat, the regional court in Warsaw shall be examining the following cases. And I would like to show you how it looks in all divisions and in family law division. So in all divisions, hearing a person in order to secure the evidence or a person with regards to whom there is a concern that her or she may not be heard at a trial, enforcement proceeding with the exclusion of tenders, enforcement warrant proceeding, cases regarding enforcement orders or refusal to issue them, cases regarding security warrants of a refusal to issue them, cases regarding the issuing of copies of valid decision. So with regard to family law, we have a long list of cases are running during the epidemic time. So these are the cases regarding the taking away of a person who is subject to parental authority or has been committed to someone's care. That's I think, the most important case. Then we have some cases under the Code of Civil Procedure. These are urgent matters activity of family court. Then we have the Mental Health Protection Act. So that is, for example, a situation when we are placed a person in a hospital and the person has a mental health problem. Then we have cases regarding the placement of a minor in a youth detention center or the extension of the placement duration. Then we have cases regarding minors who have been placed in a youth detention center, cases regarding the placement of minor foreign in a care or education center, cases related to the motion refer to the act of counteracting domestic violence. Is a new regulation, very new. Is such a regulation as in American law isolation order. It doesn't work in each country. So, for example, it works in United States, in Austria, in Spain. Cases regarding the safeguarding of directly job, paradise, best interest of the child, in particular the securing of child support. And then we have cases regarding enforcement proceeding in the following matters: taking away a person who is subject to parental authority or has been committed to someone's care. Then cases refer to mental health protection, as I mentioned before. Cases regarding the placement of a minor in a youth detention center. Cases related to a motion to appoint a guardian to represent the interests of the minor in the proceedings before the court of another institution is urgent matters. Cases to secure a reduction of child support, and cases under the act of the profession of a physician or dentist. And these are cases regard medical treatment or transplantation when the parents doesn't agree of of it. I think it's also very common in international law. So, and I asked, as I told you, my friends, judges from our association, they work in different courts. They work in local courts, also in regional courts, in very small courts, and in big cities, for example, Warsaw, Gdańsk. And I asked them, how does it look in practice, if it really looks like that? And so, what kind of findings do I have in the feedback? So, of course, as you can imagine, the judges work in mask and in gloves. Also, the parties also need to use all the security equipment coming to the court. That was organized like that the parties not goes on the same time to the court. It was shared that the people don't come together on the same time. The ICT tools were used during the pandemic, were used under the Shield 3.0. That's the Shield during the pandemic of this all regulation, how not only courts but all the public institutions, for example, has to run. And under this law, is allowed to use in the court, for example, video conferences. As I was told by my French judges, video conferences were not used that wasn't a popular tool. That was used only in few cases, not in all courts. To be honest, the judges say there were only one scholarship for them how to use it, but actually that doesn't work in practice. I will show you in other slides that what kind of tools the judges use. So that, to be honest, that's also very good practice, and I know it from my research I made last years. It really depends on if we are talking about small court or in small town, or we are talking about big court in a big city. For example, in a small court, a lot of things can run because the judge was calling somebody, make a phone or send an email. And in big courts, when I was asked my friends, they said it's impossible because, for example, to the regional court in Warsaw, every day are coming about 1,300 cases. So it's impossible to work so fast, like example in a small court in a province. What is important? So the execution, because from my point of view, when we are talking about the right to family life and of course the health, to caring about our health. So the one of the most important thing is the situation when the parents are doing divorce and they cannot find the solution how to care about the children. And to be honest, when I talk also to the judges, they say the pandemic, that was a very good tool using by parents who don't want to give the opportunities to the another partner or women or husband or wife to have a contact with the child. So even if there were not problems or if there were not the risk for health, they say now we have pandemic, so you cannot take our child, you cannot visit the child, and that is very, very sad, and I want to underline it. So the most important problem was that the execution of parents' contact with children was not included in urgent matters. So when can we now construct some findings from the slides I show you in before. So we have some types of cases that were treated as urgent. So that was cases regard to mental health. That was the placement of person in a social care house. That was the placement of a child in a foster care. And I will show you what the kind of problems the judges have in practice. And of course, complaints. When there was complaints on the decision of the court, that works because it can be run without parties. It can be run only with the judge. So it's easier when the judge is doing it on his own. And here you have examples I collect from judges. For example, there were a few hearings in the appeal court, basically placement in a social care home, psychiatric cases, complaints often issued using Microsoft Teams video conferencing. Recently at the hearing, we connect through WhatsApp. The party did not come. The other party with the attorney and had an out-of-court settlement, and we have to ask more questions. That was an example when some informatical, technical tools were used, and that was a court in Warsaw. There was a case pending for the release of a child under the Hague Convention. With the consent of the president of the court, judicial Skype was established, and an applicant from Australia was heard. That's another case where when the teleconference or any kind of such a tool was used. Then I have a request for security bar suspending father's contact with the child. The father took the child to some city on weekends, and on this time there were a lot of cases of COVID in the city. I wiped his contacts, father accepted, and he don't make a complaint. So sometimes that works really like that. But I actually today I asked my friend who is a judge in a regional court, and she say till now she has no complaint on such a case. So that means when we will have it maybe in next month. So because it takes time to work on it. So there were no video conference in court. That's the answer for a small court from south of Poland. We took children twice. That means we took the children from the family twice during the lockdown. This second time was difficult because that was panic, that we do not know what to do with the child. That there is no isolation for 3-year-old. That is only for older children. In the end, they took the toddler to solitary, and the tutor was with him until the result of coronavirus test, and it takes 5 days. So as I also know from other people who are working in the system, for example, social workers, from people who are working in adoption centers, the people who are working there, they have no enough security equipment, so they cannot go, for example, to somebody and visit the house, because he has no mask, he has no gloves enough. Yes, and that was a very big problem. Also, that was also in media. I don't know if on international level, but that was a very big movement in Poland, that we have collect money to buy some equipment for hospitals, for people who are working on health institution, because the government does not give enough of it. So that also was a problem for people who are working with families in an environment. And that is a very good example. It shows how it works in small town. That is the opinion of my colleague who is working in a really, really small town. And also a very important issue, the thing if the judge is anonymous or not. Because in a big court, the judge is a person who nobody knows in a town. And in this little town, the judge is a person very common in the town. So it works easier. And she said, I direct most matters about contacts to mediation. And when I sent this information to my other colleagues, they said, it's incredible that it would work and runs so easy. I already have the first settlements. In our court, I was the first to hold a video conference. It was on a case about placement in a psychiatric hospital. I had to do everything myself. Now all judges are making video conferences on these matters. The mothers made contact difficult. I called on the parties to provide a phone number and order an interview with a curator, but carried out by phone. Sometimes some conversations were enough. In several cases, the fathers themselves admit that after talking to me or a curator, contacts were not handled. So it's incredible how it could run, that the judge is calling the party and it can be made during mediation. Yes, and then I would like to show you that these are example how now the courts are looking in Poland. So there are some glasses. There's of course the judges are using a plexi, some mask and gloves. And on the end, I would like to share with you some findings, because during the pandemic, during these 2 months, I already make a research with my friend from University of Wrocław. We make a research about actually what does mean that the foster family care is temporary, because that's the problem. The problem are the children are placed in a family, foster families, and they stay there till 18 years old, and they are not, they cannot go back to the family because the family still, the parents have still the same problems they had before, and they are not going to adoption. So actually the foster family is not temporary, but it's long-term care. And during the pandemic, that was also a very good opportunity to ask the family, the foster family parents, the foster parents, how does it work? For example, now with contacts with biological parents. And they told me that, of course, now in regards to the pandemic, all the contacts were cut, and the children cannot contact with the parents because it's a risk for the whole family. For example, when in a family there are 8 children in a foster care, so it's when there's one parent is coming, that's the risk for all children and the parents. So, and they said actually they can observe that was not so bad for the children, because they can slow down the emotions. They have not emotional problems, that's because sometimes the parents are coming and they are not in good condition. For example, they are coming after alcohol or something. And they said that they say that was a good opportunity, good time for the children, isolation time. But also we have in Poland some cases that the people who are working in houses for children, so foster houses, were infected with a virus, and that was a problem, because then all the people who are working there and also all the children need to be under isolation. But I think that's also a very common problem. So I think that's all my findings for now. Of course, if you have any question, how does it work in Poland, I'm open for it. And thank you very much. That's it.
Thank you very much, Magda. It was very interesting. Oh, the pictures from the course, it is very interesting, and also these debates about what is urgent in these situations and how children's rights are considered, using the argument of COVID to avoid the parents to have contact with the child, and also the possibility of mediation. I think it's very important. So thank you very much. Now we have the opportunity to listen to Judge Jean-François Noël, who was appointed to the Court of Quebec Youth Division in May 2018. Previously, he practiced law at the Department of Justice of Canada between 2007 and 2018, where his responsibilities included representing Canada in various intergovernmental fora, including the United Nations Commission on Crime Prevention and Criminal Justice. Prior to this, Judge Noël was the Director General of the International Bureau for Children's Rights in Montreal, where he played a leadership role in the elaboration of the United Nations Guidelines on Justice in matters involving child victims and witnesses of crime. His previous experience also includes teaching child law at the University of Montreal's law faculty and working as a specialized educator in youth rehabilitation centers. It's a pleasure to have you with us, Jean-François. You have the floor.
Thank you very much, Eduardo. So good afternoon or morning or evening, depending on where you're joining us from. I'll start with just a few words to give you some context in relation to my role in the court where I'm sitting. So the Court of Quebec consists of provincially appointed judges that are sitting in 3 chambers, so civil, criminal, and youth. And while my colleagues and I may be called to sit in all 3 chambers, the majority of us are either appointed to 1 or 2, or in more remote areas, they're called to sit in all 3 chambers. Myself, I'm assigned to the Youth Court Division in the Gatineau area. So to situate you, Gatineau is directly across the river from Canada's national capital, Ottawa. And as a judge in the Youth Court Division, our main responsibilities have to do with youth protection, so children aged up to 18 whose security and or development are endangered, and that's the vast majority of our time that is spent on youth protection. We also deal with children in conflict with the law, as well as with adoption. Now, family law, insofar as custody and access in the context of divorce, for example, is concerned, is really dealt with by the Superior Court of Quebec, which consists of federally appointed judges. That being said, there are certain circumstances where the Court of Quebec may be called to rule on custody or on other issues such as emancipation, the exercise of parental authority outside specifically of the case of youth protection. So really this happens if the court is already seized of a matter in relation to adoption and youth protection, and ruling on custody, for example, would enable to settle, if not the entire issue on youth protection, at least one of the main ones. Then in that case, the Code of Civil Procedure allows the Court of Quebec to handle those issues. For today, my remarks will be mainly directed at the area of youth protection. I will speak to a lesser extent about custody and access in the context of the Superior Court and with regards to what happened during COVID-19. And I will end my presentation by saying a few words in relation to how the whole situation really has impacted our work in and out of the courtroom. So beginning with children's family contacts during the pandemic, there are a number of rights and principles found in the Youth Protection Act of Quebec that have a bearing on the determination of a child's contact with his or her parents. I'll just highlight a few. Obviously, first and foremost, all decisions have to be in the interest of the child and respectful of the child's rights. That's in Section 3. Any intervention in respect to a child and a child's parent under the Act must also, if the circumstances are appropriate, favor the means that allow a child and a child's parent to take an active part in making decisions and choosing the measures that concern them. We should encourage the participation of the child and the parents and the involvement of the community. Parents must, whenever possible, take an active part in the implementation of the protection measures as well. The child has a right to confidential communications, obviously with his or her legal counsel, as well as the right to confidential communications with his or her parents, brothers, sisters, and any other person really, unless the court decides otherwise. Every decision made under the Act must aim at keeping the child in the family environment. Obviously, there are cases where that's not possible, but that's the aim. The persons and courts called upon to take decisions respecting a child under the Act must give the child, his parents, and every person wishing to intervene in the interest of the child an opportunity to be heard. Now, there are a number of protection measures that can be ordered once the court has determined that the security or development of a child is in danger, or during the interim, so that means during the court process as well. This includes determining the modalities of contacts between a child and one or both parents and other family members. This, of course, is most often done when the child is entrusted only to one parent or to an alternative living environment. Now, in face of the situation with the COVID-19, the government of Quebec declared the public health emergency on March 13th. So mid-March 2020, that's when schools were closed, and that's when generalized confinement measures were put in place. Several measures were ordered, and I will only speak to those that have a direct bearing on the issue at hand, and that is mainly children's contacts with their parents. So on March 19, 2020, the Quebec Minister of Health and Social Services issued Order 2020-006, which reads as follows. I will read it instead of just giving you my impression on it because there was some disagreement in terms of how it should be interpreted. So I'll give you the first hand, and I'm sorry I don't have a PowerPoint, so you'll just have to bear with me. So here's how the order reads. And again, that's an order from the Minister of Health and Social Services. The conclusions of judgments or orders rendered by the Court of Quebec ordering contacts in the physical presence of the child with his or her parents, grandparents, or any other persons are suspended to the extent that the Director of Youth Protection considers, according to the public health recommendations, that those conclusions cannot be complied with in a way that protects the health of the population in the context of the COVID-19 pandemic. The Director of Youth Protection must, where possible, provide for other safe contact terms and conditions by any means deemed appropriate, in particular by technological means. The Director of Youth Protection must allow the execution of conclusions as soon as they may be applied without representing a danger for the health of the population. End of the order. Now, this should have led to a case-by-case, at least in our view, analysis to assess whether physical contacts can be arranged in a safe manner. Instead, it appears that youth protection authorities across the province started implementing a blanket approach, suspending all physical contacts, including those ordered by the courts, except in exceptional circumstances. Measures were put in place, and that seems to be where the efforts were directed. Measures put in place to organize other means of contact. So as in most parts of the world, I mean, using FaceTime, Skype, or other. Evidently, it's quite difficult to meet a child's emotional needs using such virtual contacts. Particularly, I guess the impact is felt for children with special needs and very young children who perhaps have yet to develop a secure bond with the parents. You can only think of children born during that time who, for various reasons, may have been removed from the family environment and entrusted to a foster family, and then no physical contacts for a long period. That has obviously a tremendous impact. Now, allow me to open a short parenthesis regarding the situation in family matters, because I want to keep this chronological, because it all sort of happened in the same time. So in terms of the Superior Court, on March 27, 2020, Judge April of the Superior Court rejected a motion presented by a father seeking to suspend a mother's visitation rights and replace them with virtual contacts by means of Skype or FaceTime. In her decision, Judge April noted the importance for children to continue to see both parents. She also noted that the COVID-19 pandemic in and of itself, and in the absence of symptoms for the individuals concerned, does not justify the modification of shared custody orders as long as parents are taking the necessary precautionary measures. Also, she noted that decisions and orders meant to ensure that children can benefit from the presence of both parents must be respected. So that's on March 27th. On March 30th, 2020, so 3 days later, Quebec's Minister of Justice announced a temporary measure allowing the suspension of decisions and orders from the Superior Court this time, relating to supervised visits between a child and his or her parents or grandparents in the event that the community organizations, because those are really the community organizations that are responsible for the supervision. So in the event that those organizations supervising the visits consider that the order or decision cannot be respected in a manner that protects the health of the public, again, in the context of COVID-19. So going back to youth protection matters, on April 28th, 2020, the Superior Court had to rule or was seized of a decision that had been made by the Director of Youth Protection in the implementation of Order 2020-006, so the one that basically led to a blanket suspension. And so a parent addressed the Superior Court in relation to that, complaining that the order should be quashed. So the court agreed, and really we have to bear in mind in this particular case, so there had been a decision rendered by the Court of Quebec ordering physical contacts between the mother and the children that had been done at the end of January, and then following COVID-19, it all was suspended, and the mother addressed the court about the issue. So in her decision, Judge Bergeron noted that the Director of Youth Protection's decision to suspend the contacts is based on the general public's health and not on the health of the people concerned in that particular case. The decision also reiterates that the interests of children are paramount and that physical contacts cannot be compared to contacts by way of technological means. So the very next day, on April 29th, the Commission des droits de la personne et des droits de la jeunesse, so that's a provincial body responsible for promoting and upholding the principles contained in the Charter of Human Rights and Freedom, the Youth Protection Act, and the Youth Criminal Justice Act, addressed a letter to the Quebec Minister of Health and Social Services on a specific issue of the implementation of the Order 2020-006. In the letter, the Commission expressed its concern that the Directors of Youth Protection were automatically suspending all physical contacts between children and their family without proceeding to an individual evaluation. The Commission also stated that such a blanket approach is susceptible to infringe on basic human rights of children, including the right to life and to personal security, inviolability, and freedom, Section 1 of the Charter of Human Rights and Freedom, the right to the protection, security, and attention that the parents or the persons acting in their stead are capable of providing, Section 39 of the Charter, and all decisions concerning a child, the fact that all decisions concerning a child must be made in the child's interest and in respect of his or her rights, again, Section 3 of the Youth Protection Act. So finally, the Commission asked the government to intervene without delay and to end the systematic suspension of physical contacts between children in need of protection and their parents. Less than a week later, on May 5th, the Quebec Minister of Health and Social Services revoked the previous order and issued a new one. In essence, the new order provides, and I'll give you the highlights, provides that the Director of Youth Protection is required to arrange in a manner that enables the health of the population to be protected for physical contacts between the child and his or her parents, grandparents, or any other person, pursuant to the conclusions of a decision or order made by the Court of Quebec, if the child or any other persons with whom contact has been ordered, or a person from the child's alternative living environment, so a person from the foster family or family environment, is in one or a number of different situations. So either there's a COVID-19 diagnostic for or a contact with such a person, either there's someone in that environment waiting for a COVID-19 result or showing symptoms or returning from travel outside the country, or there's someone, the child or someone from the child's alternative living environment in a particularly vulnerable situation with regards to the virus. So the Director of Youth Protection is now required to facilitate such contacts at all time, unless aware that this is impossible, and in such cases, alternative remote contacts is to be arranged. The conclusions of decisions or orders are to be suspended only if the Director is of the opinion that neither physical or remote contacts can be arranged, and the Director is required to allow full execution of the decision or order as soon as the situation allows it. The measures also apply to the conclusions. So in the new order, the measures also apply to the conclusions of a decision or order made by the Superior Court in relation to supervised visits between a child and the parent, grandparent, or otherwise. So this seems to have pretty much ended the debate. Unfortunately, I think we are perhaps only beginning to measure the real impact that the blanket suspension of physical contacts may have had on children's emotional well-being, and in some cases on the bond with their parents and other family members. To my knowledge, we haven't seen many of those cases brought to us, like brought to our attention. It all evolved pretty quickly, and I think it's when we see the cases now that we are told, as part of the background or the report that's made to the court in terms of what happened over the last 6 months for example, that we're being informed that, well, the contacts were suspended for that period of time and they've now recently resumed. We're sort of informed after the fact, but this is the chronology tells you what happened. And I think we were all quite surprised on how the order was interpreted. And yeah. So to conclude, I'd like to say a few words in terms of how the pandemic has impacted the way we do things. So both in and out of court. Obviously, at the beginning, several adjustments were required as everybody adjusted to the exceptional and unpredictable situation really created by the COVID-19 pandemic. So as soon as the schools were closed, I mean, obviously, everybody was wondering what's going to happen with the courts. And with many other parts of the world, I guess the issue was to determine what cases will be going forward and which ones won't. So what are the urgencies and how do you define an urgent matter? In light of the public health emergency, the Minister of Justice of Quebec and the courts put in place several measures to deal with the situation. The Court of Quebec notably developed and implemented a plan to ensure the continuity of services for each chamber, while ensuring that urgent matters were heard without delay, including where youth were deprived of liberty or entrusted to a foster family or a rehabilitation center during the proceedings. Clearly, those cases were a priority and would be heard. And then it was, as time went on, it was revised, and there were more and more cases going forward. And as with other parts of the world, we started implementing measures in court in terms of ensuring the safety of everybody, and developing new tools as well to ensure that the rights of children and parents to be heard were respected while taking the necessary measures to protect their health and that of the public. While the pandemic clearly has had tragic consequences, first and foremost for those affected by the virus and their loved ones, and those who lost their lives, as well as for the children, as we've talked about, who were deprived of regular access to their family members. The situation has led to, nevertheless, positive advances, including in terms of gains of efficiency. I think it's forced everybody to reassess how we do things. How can we ensure that the cases that must be heard are heard in a way that makes sense? And I think first and foremost, it's led to better planning and better case management, at least as far as I'm concerned. I mean, both in terms of how we prepare our caseloads. So when we look at the cases we'll hear soon, where are we? What are the issues? Who's going to come to court and when? And who's going to testify by means of technological means, whether it's video or audio? How are we going to arrange that? When are people going to arrive at court? Because obviously we also are concerned about the number of people circulating in a given courtroom on different floors, accessing the elevators and so on. So it's forced us to really look ahead and plan. And I think both for judges and counsels, that's really a positive development. The better planning and preparation undoubtedly will lead to more efficient hearings. So the benefits include counsels meeting virtually or not with clients ahead of time, which is a welcome change compared to the too often seen practice of counsels meeting with clients in the hallway just before the hearing starts. So it also means a higher number of draft agreements being submitted to the judge, and that's obviously is a positive development if that that agreement meets the needs of the child and is in the child's best interest. But I mean, if people are able to both recognize the facts, so the situation which leads to the security and the development of a given child to be endangered, and able to put that on paper and recognize the situation, as well as agree on the protection measures that should be put in place for a given time to address the situation, put an end to the situation being endangered, and ensure that it doesn't continue in the future or happen again, then our role becomes more or less to look at all the situation, verify, and that's all provided in the Act. I mean, verify the free and informed consent of everybody, and basically recognize this agreement, and it becomes our ruling. And that's been in the Act, and it's been there for quite a while, but it's not something that we see as often as we'd like. And I think the situation has really put pressure on everybody to make use of that tool, because then it enables to, if everybody's signed the agreement, or if everybody's in agreement with what's being spelled out, then you can do that with everybody either on the phone or by video conference. And it saves time, and people don't have to wait for half a day at court for their case to come up. So there's a lot of positive coming out of that. And I think there's also reduced waiting times at court. We can, I mean, there are challenges in trying to organize exactly when a particular case will be heard. For example, if we have a day where there's 5 children whose situation is before us. So we look at one is scheduled to go for half a day, the others are for an hour. How do we plan? So can we say, well, we'll just hear that one in the morning, and the other ones don't come to court before the afternoon, or if you're going to join by video conference, then we'll let you know when to join. It's better to, spend a couple of minutes trying to hook up everybody rather than have everybody just waiting. So I think in terms of efficiency, it's very promising, and we're seeing the benefits now. I mean, it means we're spending much more time managing the cases for sure. It means we have to be more involved before the case even starts in terms of assessing what the positions are, or who's going to come to court, what are the witnesses, and so on. As in other settings, obviously the use of video conferences was put to the test and is now commonly used, both in youth protection matters and in other areas as well. Obviously, safeguards had to be put in place to ensure, I mean, it's a constant reminder that I use, and I know my colleagues do as well, making sure that people joining for the hearing are in a place and in a context where they can have a confidential and serene discussion, that they're not going to be interrupted, that they're not recording what's going on, that they're not going to be interrupted. And this is particularly a sensitive issue, obviously, for children. And I think the consensus is that it's for the child's lawyer to play a key role in that, to assess whether that particular child can give a video testimony in that particular setting, given everything else that's going on. So, and obviously the court can have a say, but I think there's a role for lawyers representing children, definitely, and they have to play their role in that regard. And that's it. I would say at present, I'd say that very few cases are postponed as a result of the pandemic. If I speak now, what's happening now. And it is my hope that gains in efficiency will endure and beyond the pandemic, and that will benefit certainly the children and everybody else involved. So that's it. If there are any questions, I'm more than happy to answer them. Thank you very much.
Thank you very much, Jean-François. It was indeed very interesting to see all the controversial aspects that those cases were bringing to the justice system, and particularly the positive points that you remarked that we have to observe and to analyze what we can improve our justice system. So I would remind our audience that you may make questions in our chat, and we are going now to our last speaker, Judge Connie Mocumie. She lives in Bloemfontein in South Africa. She's a judge in the Supreme Court of Appeal. She's also specialized in family law and is the liaison judge in South Africa for the Hague Convention. It's a pleasure to have you with us, Connie, and you have the floor.
Thank you so much, George. I think perhaps it would be good for us, for me, to start from where my colleague ended, with the positives of what one can look at on COVID-19, the period during COVID-19. I want to start there, just that as we go into the discussions, we appreciate what different jurisdictions have done. When the government across the world were encouraged to become more aggressive, take aggressive action to stop the spread of COVID-19. The Chief Justice of South Africa, like Department of Government, issued directions in order for the courts to, one, operate virtually. Secondly, to operate on a skeleton component, meaning as John was saying earlier on, a few people came to work and the rest were operating from home virtually. Now, that has really been of benefit. It has really assisted in bringing in efficiency. It has made us aware that there were many ways in which cases could be dealt with efficiently, quickly. It was not necessary, especially for matters under family law, to be dealt with face to face. That is what we have taken from this experience since the 26th of March 2020, when our government declared the lockdown to assist in curbing this pandemic. Now, it has also taught us that case line management is important. Through case line management, all judges have been trained now in South Africa. Those that have not been trained, training is continuing. Just to say, for the judiciary to take control of the proceedings from the minute papers are filed, the legal representatives filing their pleadings, the judge is in control, the judge knows where the matter is at the current moment, the judge knows when the trial should begin, and that way monitors and controls the proceedings up until they are completed. I am just echoing what John was saying, that the positives are definitely there after all the trouble that we have been through. Back to my presentation, as I indicated, South Africa responded like all governments around the world to put in place measures not only to ensure that people were safe or that the pandemic was not spreading, but to also reverse the pandemic from growing and give itself some time to look at what else can it do for the vast majority of South Africans that are not on medical aid. It's only a handful that's on private medical schemes that could have managed to survive during this pandemic. I am referring specifically to this for me to address the issue on the right to health in South Africa. The right to health in South Africa is provided for under Section 27 of the Constitution. And it is a constitutional right. But once a pandemic of unprecedented nature came in, obviously human rights, constitutional rights that were enshrined had to be limited one way or the other within the confines of the Constitution. Our Constitution, fortunately, has a Section 36, which provides for limitation of those rights when necessary. Now, as a result of this national state of disaster, on 26 March, the South African government, through the Minister of Cooperative Governance and Traditional Affairs, designated under Section 3 of the Disaster Management Act 57 of 2002, declared a national state of disaster in relation to COVID-19 pandemic. A lockdown was enforced to address the disaster. It meant everybody's movement, all citizens of this country's movement were literally stalled. Everybody had to stay home and not do anything except those that were providing essential services. I just want to say the minister promulgated those regulations, and it would perhaps be appropriate to read the applicable regulation just to make it clear what is provided so that I don't misquote it somehow. The regulation amended previous regulations of 30 March 2020, the original one, and state in the relevant part, Regulation 11 capital B of the regulations is hereby amended by the substitution of paragraph A of subregulation 1 of the following paragraph. For the period of the lockdown, every person is confined to his or her place of residence unless strictly for the purpose of performing an essential service, obtaining essential good or service, collecting social grant, pension, or seeking emergency, life-saving, or chronic medical attention. But importantly, under subparagraph Roman figure 3, movement between provinces and between metropolitan and district areas is prohibited, except for essential workers who have to travel to and from work, for transportation of cargo from port of entry to their intended destination, on condition that the necessary precautions have been taken to sanitize and disinfect such cargo, for the transportation of the mortal remains, and for attendance of a funeral as provided for and on the conditions set out in sub-regulation 8. Now, based on these regulations, there was no movement between the provinces, including the movement of children between holders of parental responsibilities during the lockdown period. You would remember I said the lockdown started on the 26th of March 2020. It would have continued until end of April, but then it had to be extended. But as I was saying, the movement of children was automatically affected. It meant holders of parental responsibilities who were in different provinces could not exercise their parental rights, could not have contact with their children, could not, as one of our colleagues just said now, others even abused the lockdown period to ensure that the other partner does not see or exercise their contact rights. Now, the directions were amended because of the drastic and that impact on movement of children. They were amended on 7 April 2020 to introduce an exception to the prohibition, which permitted the movement of children in certain circumstances. The amended direction 1C states, and I quote, 1, paragraph 6 of the direction is hereby amended by the substitution in subparagraph M for items 1 and 2 Roman figures of the following items. Roman figure 1, movement of children between co-holders of parental responsibilities and rights or a caregiver as defined in section 1, Roman figure I, of the Children's Act is prohibited, except where arrangements are in place for a child to move from one parent to another in terms of 1, a court order, 2, where a parental responsibilities and rights agreement or parenting plan registered with the family advocate is in existence. But importantly, a proviso was inserted that in the household to which the child is to move, there is no person who is known to have come into contact with or is reasonably suspected to have come into contact with a person known to have contracted or reasonably suspected to have contracted COVID-19. Now, between 26 March and 7 April 2020, there was an amendment which meant children could then move from one province to another, could then move on those particular provisions. Now, this, however, was a problem when it had to be, the regulations had to be implemented at a practical level. If you listen to what I was saying, the regulations only made provision for movement of children between the two parents. That was it. It did not make provision for instance, the caregivers, such as grandparents who were not in the same province. It did not specifically and expressly say so. The amended regulations were simply aimed at ensuring that existing parenting plans made an order of the court and those registered with the Family Advocate's Office were implemented, but those of parents that did not have those arrangements in place were not catered for. And of course, we know there are people that are not married but have children together. There are children that are raised by grandparents whilst the children are working in another province. So it became very difficult for people, especially because the regulations could only be challenged in the high courts, not the magistrate court that is responsible for the bulk of the cases in South Africa. Now, the regulations in essence ignored the many parties who have amicably reached agreement without the intervention of the court order, for instance. Parties who have behaved responsibly in the best interest of the child that were now under the regulations penalized as if they don't have those arrangements in place. Courts were inundated in South Africa, mostly from the commercial side. But in terms of family law, we have 3 main cases that came before the courts, to the high courts. 2 are not of relevance for me as I'm discussing now, because they started in 2018. The judges there just made reference to how the parenting plans could be implemented under COVID-19, just to say to the parties, if you are not agreeable, do come to court or communicate with the registrars. The matter will be treated as an urgent matter due to the circumstances. The one I want to concentrate on is that of, I will just put it on record, CD and another versus the Department of Social Development, 2020, ZAWCH, that is a Western Cape High Court matter, which was delivered on 14 April 2020. Now, this case, the factual background are essential, briefly, that on 22 March 2020, which coincided with the school holidays, 2 minor children, a 10-year-old and a 7-year-old, traveled from Cape Town, which is in the Western Cape. Eduardo, you were in Cape Town, you know. They traveled from there to Bloemfontein, where I reside, in the Free State. As I said, when the regulations were promulgated, were implemented, were put into effect by the Minister of Cooperative Governance and Traditional Affairs, when they were actually published, I'm sorry, the children were already in another province, which is not their home. Their parents were in the Western Cape. They were visiting their grandparents, as they usually do, just for the short period of school holidays. Now, because of this lockdown, they were literally stuck in another province. They couldn't go. The grandparents are elderly. They were amongst the group age-wise that were at high risk. Therefore, not only were these children put at risk by the implementation of the regulations, they were literally prevented from being with their family, from being with their father and mother, from exercising their right to family life, which is guaranteed, not necessarily in our constitution expressly, but under section 28(1)(b) in the form of family care, and as our constitutional court has accepted all along that it does, one can define it as family life. Now, because they could not move, they could not exercise their family life, their right to family life, the father, who was the first applicant in the High Court, approached the High Court together with the mother, challenging the regulations to say the legislature could not have intended such absurd results, even if it did not make provision for grandparents or the specific situation these parents found themselves in. Now, I want to read this part where the court had to look at the regulation that I read earlier on. The High Court found that the best interest of the children would undoubtedly be served if permission was granted to get one of the parents to fetch the children, despite this prohibition of movement between two provinces, to fetch the children by traveling to Bloemfontein from Cape Town. The well-being and the physical health of the children in these turbulent times should not be placed at risk, the High Court held. What is important for me in that case, in interpreting the regulation that made no express provision for the movement in these particular circumstances between the grandparent and the parent, not necessarily the two caregivers ordinarily included in a family advocate report or the agreement that they had in place after the divorce. The High Court held at paragraph 11.1 that an inclusion in the exception of movement between parents and caregiver would be an interpretation in line with section 39(2) of the Constitution of South Africa, exhorting as it does for legislation to be interpreted to promote the spirit and purport of the Bill of Rights, in this case, section 28(2) of the Constitution and the Bill of Rights. That section states that a child's best interests are of paramount importance in every matter concerning a child. The court continued under 11.2. The amended direction does not specify that movement of children can only take place in terms of a pre-existing court order, as alluded to by the respondent. That was the Department of Social Development that was opposing the application. My reading of the direction the court held does not prevent a court from making an order as required, presumably in circumstances of urgency, and for movement of children to take place in accordance with arrangement put in place by such order. the High Court further held, in balancing the right to health and the right to family life in the context of COVID-19 pandemic, the measures taken by government must be balanced and flexible and not encroach on the right to health and family life. The rights of children include the right to family care, for parental care, to be protected from maltreatment, neglect, or abuse, to dignity and privacy, to the extent that it protects their rights to family life as provided in Section 28(1)(b, and to have their best interest considered of paramount importance. Such rights become more important during a pandemic. Thus, the court then granted the following order. It granted the following order. One, it said that one of the applicants as co-holders of parental responsibility and rights in respect of their minor children, they are as such declared that under Section 18.2 and Section 18.2b of the Children's Act. It ordered that in terms of the exception contained in Direction 1C, Roman figure 1 of the directions issued by the Minister of Social Development, dated 7 April 2020, number R455, Government Gazette, number 43213, in terms of Regulation 10, sub 8, of the regulations made under Section 27.2 of the Disaster Management Act, 57 of 2000, is granted as follows. One, the first applicant is authorized and directed to travel between provinces and between district areas from his residence situated in the Western Cape to the first applicant's parents resident in Bloemfontein for the sole purpose of the movement of the children. Two, the first applicant is authorized and directed to fetch the children in Bloemfontein and to travel back with them to the Western Cape to the residence of the first applicant. Three, the first applicant is permitted to sleep over one night after traveling to Bloemfontein at the paternal grandparents' home at the above mentioned address, after which the first applicant and the children shall return to the first applicant's address. Four, the first applicant shall travel to Bloemfontein in the first applicant's description of the car, and the first applicant and the children shall return to Cape Town in the said vehicle. Very specific type of order, which was bringing in the regulations, but also bringing in the best interest of the children. And
Connie,
five,
may you come to your conclusions because you have a problem of time?
Yeah, the children will subsequently only be allowed to travel from the first applicant's address to the second applicant in the event that the second applicant, who's the mother, is in possession of a certificate by an independent medical practitioner indicating that she tested negative for COVID-19 virus. In essence, this is one of the breakthrough, one of the most important cases under COVID-19 in South Africa that literally interpreted the regulations in line with what is expected in the best interest of the children. It took into account the best interest of the children. It took into account the right to health. It took into account the right to family life. To sum up, I am saying judges in South Africa have been aware, they have been inundated with applications of this nature, but none of these cases, the three that I have mentioned, have been on appeal yet. My understanding from the reading of this judgment is that it's just like that. There is a constitution that has to be upheld. Despite the pandemic, there are measurements that can be put in place to read the regulation in line with what is the best interest of the children. Thank you so much.
Thank you very much, Connie. Our time is over. The subject was very interesting, and I think everyone had more to say, and we would love to stay here more and listen more to you. We have two questions, three indeed. I don't know if I asked Joseph, Magda, and Jean-François, they had time. If we may make very quick answers, I would appreciate, but we would give a feedback to our to the attendees of our webinars. So the questions are, what were the most significant cases or complaints related to children's rights during this period that were not so common before, if they were? And the second, was there an increase of placement of children deprived of parental care due to death of parents and relatives, poverty, reasons, or domestic violence? If so, were there alternative measures and which ones? There was a third one related to penal institutions. I would leave it for the person who made it. I would ask her to watch the previous webinar because it was focused on this point, and we could focus now with family issues. So I'll give you the floor. I don't know if everyone wants to speak. If so, you have all of you the floor. Who wants to answer the questions? Oh, some of the questions. Joseph?
As I spoke before, I would like to leave the others, but it doesn't matter. Concerning the first question, can you repeat a little bit?
Different kind of cases that were not common before due to COVID.
I think the most complex case are in fact because the first phase of lockdown is done, but not the second and the third. The case of child abuse and child maltreatment at home. I think this was very complex because you don't have only to manage with the juvenile court involvement, but also with the criminal proceedings of the adult and also other interventions. Then this was very complex to manage with all the availability, police, magistrates, and so on. Yes.
Thank you. Do you want to make? Yes, please, Jean-François.
Okay, I just wanted to add it. I think what we, and that's not necessarily based on actual cases that were before us, but I think everybody's realizing that there were additional pressures put on families and family environments in relation to school being suspended, the kids being at home all the time, some of the parents teleworking, and also you combine that with the fact that schools and daycare centers are often, they're a safety net. They're the area where certain situations will be noticed and reports will be made. So I think that's something that is a significant change. I think it may take a little bit of time for these things to actually come to court. But I think as things go back to normal, this is where we're going to be able to assess the impact. But certainly, without having any data to provide to you, I think it can be reasonably expected that the number of reports, our system is based on reports. So that means that people that are in contact with children that have information, that's concerning in relation to the child situation, and they make a report to the Director of Youth Protection, and there's an evaluation and so on. Those numbers most likely have gone down because of the pandemic, because again, no outside daycare centers or schools to make those reports. So I think that's certainly something that's a little bit concerning. So we'll have to wait and see in terms of how big of an impact it is, but it certainly has had, it's changed everyone's lives. I mean, so in one way or another, I don't think there's anyone that wasn't impacted by this. So, and in terms of the second question, I certainly have, haven't seen an increase in the in placements or resorting to alternative care. I don't think that's something, I don't have any data on this, but I don't think there's been more. I think it's always a case-by-case basis. The way we assess this is really about the particular situation of that child and the parents and everybody else around that child. And if there's a need for that child to be entrusted outside the family environment, then that's because of not COVID-19, but really of the particular of that situation. Of course, COVID-19 could be a factor if there's a, but I haven't seen it. I haven't seen a child being displaced because of COVID-19. I think maybe perhaps in our area, we've been fortunate enough to not have that many cases being confirmed. So that's not been brought to my attention.
Can I add something for the second question?
Yes, please.
Because in fact, we had a lot of cases of, more cases of conflicts at home, of course, of the parents. And this, of course, have also an effect for the competence of the juvenile court, because we are not competent in the separation and divorce, but of course, in the case of serious prejudice, files that was opened for this kind of situation. And I would like just to add a last thing. I think that this is a really personal point of view, but I thought that the children were more resilient than adolescents and adults. I realized this during this month of the pandemic.
Thank you. Magda, and then Connie.
Yes. Thank you. Unfortunately, I don't have data to answer the second question, but I would like to underline two very important issues. First one is that many experts, for example, also we giving the Force to the Children Foundation is showing that we can have a huge problem with abuse against the children at home, because we don't know what's happened there actually, because everybody are isolated and close in apartments and in houses. So we don't know what is the situation of the children. That's the one thing, and a very big problem actually. That's also a challenge how to check the situation. And the second thing, I don't know how it looks in other countries, but in Poland we have thousands of children who are dismissed in an educational system. So they have no laptops, they have no internet connection, and actually there is no system to check what's happened with the children, and it's not sure what will be in the future if children can go back to school in September. But also that's the question. I just want to put it here that we'll remember about it.
Thank you very much, Magda. Connie, your microphone.
Oh, I just wanted to add, in South Africa, we saw a surge of domestic violence matters in the family courts. But as my colleague was saying earlier on, it's very difficult because there has been no study, no report as to how many do we have. But what I know is that it was that high for the president of the country to speak out against that, because a number of young women were even killed during this period. So there is that connection, which we will probably look at later, but it is there. Domestic violence has gone up extremely high. I just wanted to share that.
Okay, thank you very much, Connie. Our time, unfortunately, is over. It was a pleasure to have all of you with us, Joseph, Magda, Jean-François, and Connie. I learned a lot, and I'm sure that all our audience has also enjoyed very much this webinar. I want to highlight that this webinar will be posted on our YouTube page with subtitles in all languages. And I hope you can come and follow our webinar programs. We have another webinar in July, the 25th. Probably there will be a slight change on the dates, but it will be on the General Comment 24 from the Committee on the Rights of the Child with Professor Anne Skelton from South Africa again, and also Justice Iman Ali from Bangladesh, and Judge Jorge Jimenez from Spain. And I think it will be also very interesting. I hope to have you with us there. So thank you very much, Joseph, Magda, Connie, and Jean-François.
Thank you
and
very
take
much.
care.
And thanks. Yes, you too. Bye.
Bye.
Goodbye.
Thank you.
Bye-bye.